Hi, everybody. My name is Carrie Goldberg, and I'm very, very excited to talk to you all about legal options for you if you or somebody that's close to you or a client has been the unfortunate victim of a deepfake situation. I'm joined by my dog, Remy, who might bark if he hears any noises. So please bear with me. I'd love to, so I have 15 minutes to talk to you. I would love if you could submit any questions that you have. If you could just submit them in the little chat box, because my favorite way to talk about things is to answer questions. But until you have questions, I'm going to riff a little bit. So I want to just express a huge shout out to the organizers of today's event, or today and yesterday's event, especially My Image, My Choice Coalition survivors. The White House has been a huge leader when it comes to artificial intelligence and deepfakes, and I'm super grateful for them even prioritizing it enough to put it into the put language about deepfakes into the executive order on artificial intelligence. So my pleasure is to sue. That is what I do. I own a law firm that does civil litigation, and we represent victims of catastrophic injury who have been, in most cases, harmed because of something that happens on the internet or because of an online product. We have many different options when it comes to protecting a person's rights. We typically try to do the least invasive option first. So if somebody comes to us and tells us that images of them have been submitted online and are going viral, our knee-jerk reaction is not just to to plaster the world with lawsuits. It's to figure out what can we do to stop the bleed. In most cases, our client's biggest priority is to get the images removed. And so we can, depending on what platform the material's posted on, often we can just use different remedies to through the platform to get it removed, just going into their terms of service and using their forms, and same with once we get the images removed, or while we're waiting, we can also then go to search engines and use their tools. I think probably other people, including my colleague Norma, who's going to be speaking later today, is going to talk about that. We have so 10 years ago when I started my firm, there was so much emphasis on victims of non-consensual pornography. They were, and we didn't have any laws to protect victims. There were like 3 in the whole country. And over the years, working with Cyber Civil Rights Initiative and other advocates, we helped to get laws passed to criminalize the dissemination of image-based abuse. And interestingly, but not surprisingly, we now see that deepfakes has filled that void. And most laws that criminalized image-based sexual abuse are not expansive enough to also include deepfakes. And so one of the things that we're seeing is a lot of states are slowly, one by one, modifying their non-consensual pornography laws to also cover deepfakes as well. So if you are the victim, then you can report it to the police, and we can let you know if you live in a state that considers it a crime. Of course, there being a law is not always a complete legal solution, because the government has a total monopoly on what cases get investigated and referred to a prosecutor. And it's not always the cases where somebody has been the victim of an image-based harm. And so it can require a tremendous amount of advocacy to get a crime like non-consensual pornography or deepfakes to be prioritized by the police. Some of the states that have criminal laws also have civil remedies. And so what that means is that whereas the criminal laws are laws that prosecutors have the exclusive remedy of using to punish offenders, civil laws are when the victim is in the driver's seat. So they would hire a law firm like me to basically sue the offender. And we can sue, in the states that have deepfake laws, we can sue under deepfakes or under the deepfake civil remedy. But if you're in a state that doesn't have that, then we can also sue under other laws that might be appropriate. There's some experimentation right now about whether defamation laws could work. If your image has been supplanted onto another person, then that might be being presented as the truth, which might trigger defamation laws. There are other remedies. So basically, anytime you sue, you have to show that the harm happened, but you also have to kind of sculpt the harm into a cause of action. And so that might be defamation or a deepfake civil remedy or an intentional infliction of emotional distress remedy. But that's a problem that lawyers have. But the other thing to think about when you're deciding whether to bring a lawsuit is, who are you suing? The civil remedies, the main purpose is to, civil courts basically are dealing with money. And so the lawsuits, like remedy, is almost always to basically reallocate money from the wrongdoer to the person that they've harmed. So it requires, if you're going to be suing for money, then you have to, one of the things that you have to be thinking about, and your lawyer will be thinking about, is, does the defendant have money that we can be suing for? Lawsuits are not generally fun. They can be invasive and intrusive and time-consuming for victims. And so it's important to be thinking about, how you can actually benefit from a lawsuit. Sometimes people come to us and they say, well, I would like to sue the platform where my deepfakes or my non-consensual pornography has been published. And so, there are websites there are places like Mr. Deepfakes or Twitter, where we see a lot of deepfakes published and spread. Now, maybe some of the people on, at this web seminar have heard me talk about Section 230 before. I'm a very passionate opponent of Section 230, which is a federal law that basically immunizes tech companies for any conduct that one user does to another user. And so it makes it so that it's almost impossible to sue a publisher like Twitter or Mr. Deepfakes if some other person has uploaded the material to that website. So even though, if we look at the case of Taylor Swift, when she was deepfaked, I mean, her images proliferated, to the tune of millions of people and followers, and on Twitter alone. And had she wanted to sue Twitter, most likely, if not almost 100% likely, her claims would have been thrown out because Twitter would have said that they were immune from liability under Section 230. We at our law firm have, for the last 8 years, been pioneering different ways to get around Section 230. Sometimes our opponents say that we like to skirt Section 230, and we are unabashedly, will admit to that. because it's just not fair that they can basically mint money off of their users and really cause harm, by spreading things like deepfakes or other image-based sexual abuse without any repercussions. So sometimes we sue them saying that their product is defective or there's a manufacturing defect or failure to warn. We use these product liability claims to sue platforms. That may, or it's probably unlikely that that would work when it comes to deepfakes. But one thing I've been thinking about a lot is in situations where the victim knows what product was used to create the deepfake. I think that there could be really interesting and compelling lawsuits against the product manufacturer, because a lot of these products like Nudify, I mean, they exist for no reason other than to harm. And just to create deepfakes. There's not some other utility for these products. So I think that they could be considered unreasonably dangerous and could be subject to a lawsuit for strict liability. I know I'm talking like all lawyerly, but I'm here to talk as a lawyer, so bear with me. So I think that there could be interesting claims against them as a product manufacturer, or this is maybe even a little more cutting edge. There could also be some distributor liability. So we have, so these products like Nudify are not just, you don't just buy them at the store. You buy them from the App Store or from Google Play. You download them, even if they're free, you're still basically buying them. You're just sharing, the transaction is not free, of course, even if it is free. And so I've been exploring different theories of holding those marketplaces, i.e. the App Store and Google Play, liable under distributor liability. So they could be negligent for knowingly selling a product that was unreasonably dangerous and defective. So to be continued as to how that works. I have 1 minute left and I have lots of questions, which is probably going to take my whole minute to just read them. Okay, I'm going to answer Kaylee Williams' question. Do victims have any recourse under existing copyright laws? Super tricky question, and it's going to be dependent on a case-by-case basis. But whoever took the picture generally has copyright in that image. But if a picture has been transformed from one thing to another thing, then whoever has transformed it would be the one who would have copyright under the law. And so it makes it so that victims of deepfakes probably would not have copyright. And there's kind of an open question about the copyrightability of illegal material, which also muddies the situation a little bit. I'm going to just keep talking until I get a notice telling me to stop. Oh, I think I just got that notice. Okay, I did. Okay, I'm going to stop talking. But I just want to say thank you for having me. And I'm so excited that this webinar exists.